Okay, Mr. Richie.
Good morning, and may it please the court. I'm Sheldon Richie, along with David Long Daniels. We're here representing BHS. BHS and Power Standard, which goes by various other names, including KVP, are both in the transmission and distribution business, which is power across lines and then power to the ground. Both of them represented a company called Encore. So that was a customer of both companies. Back at a moment in time, KVP decided they wanted the Encore job in Dew, Texas. I believe it was for a new shopping center, and the lines were going to provide power to that center. This case, you're going to hear a lot about all the things that BHS didn't do during the case. The judge did not rule in this case based upon any of that. What the judge ruled is that our damage model was speculative. What that means is that the judge had our damage model, because to determine that it's speculative, the court had to know that it existed, how it existed, what it contained, and where it came from.
Well, was the damages model the evidence that contains the damages model, was it part of the disclosures or other evidence that were not produced timely under the discovery schedule?
Well, that's what the defendants would tell you.
Well, I mean, no, I know you say that the court didn't rule correctly and should have allowed that evidence in, right?
Yes.
But I'm asking, is the evidence you're talking about, the damages model, was it part of that universe of evidence?
The damage model was disclosed through testimony in depositions, but it also came from the defendants, who not only concurred with the damage model, but provided the damage model. So they're not surprised by it.
Okay, so if that's true, why does all the argument about the motion to strike and the hearsay and all that, why does that matter?
It doesn't matter. Wait.
Okay, it doesn't matter.
It does not matter.
Okay.
The court had the damage model.
All right.
We've presented you a book that we presented because you already have this information, but we wanted you to focus on it. So first, if you look at tab 3, I think it is, or tab 2, and you go to page 20, and I've got that wrong, but the court, it's page 29, I'm sorry. Again, page 34 of tab 2, this court has held since 1961 that the procedural rules don't trump substantive law and the merits of a case. There's no rulings on the merits in this case. And what the court, the Fifth Circuit, said in Hambers versus Woolworth, the federal rules indicate a general policy to disregard technicalities and form and to determine rights of litigants on the merits, and to that end the rules are liberally construed. Here, you've got admissions by the defendants that the damage model is their model based upon an ongoing contract with Encore, not some future revenue, based upon ongoing contract that BHS had with a customer that both were serving, but not on the same job.
So I guess tell me then, what is the evidence that I should look at in the record that will show the damages model that is not, that's not speculative?
If you go to Exhibit 3,
Tab
page
3.
29, I'm sorry, not Exhibit 3, it's in the book, and you go to, I'm a little bit out of sequence here, let's see. If you go to Exhibit 2 and you look at pages 22 forward in bold, you will see the damage model that was disclosed in response to a motion to compel that was granted by the court to modify Exhibit 16 and bring forth a more thorough damage model. And so, in fact, BHS did that. It complied. But what's important about that is defendants chose their remedy. They didn't like the damage disclosure. They didn't go to court and ask to strike the damage model. They didn't go to court and ask for a death penalty sanction. They went to court and they asked for a motion to compel, and that motion was granted, and it was responded to. And the court obviously had the response, the district court had the response because they determined it was speculative. And under Texas law, speculative is it has to be based upon some fairly definite standard, established experience, or direct inference from the known facts. This was ongoing. Encore was being charged. That job was being performed. And these defendants do not dispute that they took the specifications. They took all the crews that were working on the Encore job. They took the tools out of the trucks. They downloaded on their personal computers foremen from the companies before they resigned and went to work for Power Standard.
The evidence you're talking about, wasn't it subject to a motion to strike?
I'm sorry?
Wasn't the evidence you're talking about, the tools, et cetera, subject to a motion to strike?
Yes.
And it was granted?
Yes.
So in order to even consider that, we would have to find error, reversible error, as to the motion to strike.
Yes.
Right? Okay. Earlier you told me that the motion to strike and all that doesn't matter.
Oh, I'm sorry. I thought you were talking about the hearsay. I heard part of the question. I apologize.
Well, that's all right. I mean, but that hearsay was part of the evidentiary objections.
Right.
So how do I even get there, since all that evidence was subject to the motion to strike?
Because we've appealed that motion as well, that ruling. And what we've established in order to ask this court to overturn that ruling is that they don't even deny taking the tools out of the trucks. The court based their finding on evidence that wasn't there, which was that the value of the tools, again, was too speculative, and that the report on value was hearsay.
Okay.
These are tools, hammers, and...
I'm trying to follow your argument, but I thought you began by saying everything the court needed to decide the damages was before the court.
Correct.
Now we're back to where I thought we would have been starting, which is there was a motion to strike, which was granted, and I thought you claimed that the grant of that motion was error, and that evidence should have been admitted. I thought that was your claim. But you began by telling me, put all that to the side, everything the court needed was before it, without regard for what was struck or stricken in connection with that motion. Help me.
Well, I'm sorry for the confusion. There's two different issues that I'm really trying to address. The court said, because your damage model is speculative, we don't need to get to any of the other arguments. This is the district court. The striking was done by the recommendation of the magistrate that was then confirmed by the district court, that was then appealed to the district court. The district court ruled and said, we don't need to get to these other arguments that you're appealing because we find that your damage model is so speculative and it affects the whole case, we're dismissing the entire case. And so what we're saying to this court is the damage model was not speculative. It had a basis in fact and experience. It was testified to and admitted to by Mr. Walker, who had 14 years of experience. It was admitted to by the president of the defendant, who confirmed it. It was confirmed by the president of BHS, and it was part of an ongoing contract. It wasn't some future estimate based upon future revenues. So it meets all of the indicia of a non-speculative piece of evidence.
The fact that you didn't provide Mr. Walker's this calculation based on Mr. Walker's experience and expertise until after discovery had closed, that fact has nothing to do with what you're arguing today. Is that what you're saying?
We're saying discovery hadn't closed because the motion to compel granted a forward-looking time for my client to respond, and they did, and the ruling occurs. The supplement is filed in January with all the information in it. You get a ruling, so all the information's there on these damages, but the court says, because we find it speculative, we don't need, the court literally said, the district court, we have no need to rule on the remainder of the topics that have been raised by BHS because we're knocking out the case because your damage model is speculative.
So you're saying there was no untimely disclosure?
That's correct.
There was no disclosure that was untimely?
At the time that the motion to compel was
That would
filed,
be a yes or no?
Well,
There either was or there was not untimely?
it was not untimely because the motion to compel was granted and my client was given additional time to respond, and they did. And so it was not untimely.
Now, as I read the district court's order, the district court said there was some evidence that came in after the close of discovery, and the district court said, I have the discretion to consider that evidence or not, and the district court exercised its discretion not to consider it.
You read
that right?
the ruling correctly.
Okay.
But what the court did not address was the fact that that same court had granted a motion to compel, allowing additional time to respond to 16, which was the interrogatory, which was the damage interrogatory.
So you're saying the district court was erroneous in
Yes.
not considering the evidence?
Yes.
Yep, okay.
Since they had granted more time, how did they then not consider what was responded to?
Okay.
That's what I'm saying to
All right.
you.
You mentioned some testimony in the record that went to support the damages model. You mentioned the Walker testimony.
A Walker testimony, a 14-year person who had worked in this industry.
Okay, so what you mentioned the testimony of two other individuals.
One of them is the president of the defendant, whose name is Brian Hoffman, and the testimony of Dustin Coble, and the testimony of Ken Leones, who is the president of my client, who all testified the same thing. This is a misappropriation of trade secrets case. And that's a whole other issue, but not before the court, about the fact that this client, BHS, was given an opportunity to identify and disclose a rebuttal witness on the issue of trade secrets because the witness that the defendants had put forth didn't file a report. There was nothing to rebut. And so we filed a motion to allow us to get an expert. We got
The testimony that you just listed, I think you listed 4 people. Can you summarize for me what's the gist of that testimony so I can ask the other side, hey, is this the damages model? Why is it?
absolutely.
And what is it?
Testimony is that the model that is used as damages is a revenue model, both gross and net, and was testified to by our client's president, their client's president, Mr. Walker, and Mr. Colby, all of whom agreed that the numbers made sense, that was the revenue stream from the Encore job.
Okay.
And I would, point out to this court that if we go down the path of affirming the underlying ruling, you're based upon procedural issues. Number one, that is in opposition to what this court has said since 1960s. And number two, it would allow a theft of trade secrets, an admitted taking of trade secrets, with no punishment to it at all.
Just assumes you're right on the merits, and I thought
And that's
you don't
another-
have any merits ruling.
Which is another point. There's no merits ruling here. What the
Were there
court
not? I
basically
thought there
said-
were alternative merits ruling in some order. Was that the magistrate or the district court? Alternative rulings on the merits. I remember reading a ruling that said, well, even assuming I should get to the merits, there was, the contract with Encore Encore could give business to other people. Wasn't there some alternative rulings?
No, basically the court said we have let me put this, not to my recollection. what I saw the court say is there's no need to discuss any of the rest of these objections to the ruling or appeal to the district court because I've ruled that the case is dead because of a speculative damage model.
Well, let's see what you said, though, in your opening brief, your conclusory paragraph. I'm going to read it. The court should, number one, you didn't have the numeral in there, but one, reverse the district court's order affirming the magistrate judge's seal memorandum on the motion to strike evidence. Two, reverse the district court's order accepting the magistrate judge's seal findings, conclusions, and recommendations. And three, vacate the district court's judgment. It sounds to me as though you're asking us to go beyond what I put the numeral one having to do with striking evidence to tell us that we should take action on a ruling on the merits. It sounds like a ruling on the merits. I'm just reading from your brief.
Well, we don't think there's, I'm sorry, Judge, are you through?
Yeah, yeah.
We don't think there's been a ruling on the merits. We think the court said quite clearly, because the damages are speculative, I'm dismissing the case. That's not a ruling on the merits. That's a ruling on the evidence, and we think that he was as a sitting trial court, he was ruling on the weight of the evidence, not the existence of the evidence. If you've got the plaintiffs and the defendants both agreeing that the numbers are accurate, but one of them says, well, there's no trade secrets, and so we win, and the other one says, well, we have trade secrets, so you lose. That's a fact question. And this is a
Okay, all right, you've answered my question, and I took you over your time, but your side has saved your full time for rebuttal.
Thank you.
Thank you. Mr. Cooper?
May it please the court, my name is Chase Cooper of Winston & Strawn, representing the defendant appellees in this matter. And Your Honor, BHI has had every opportunity to prove its damages, including multiple extensions to the discovery period. I'd like to get into some of those.
First tell us whether there was any late filed discovery. I mean, I asked about that earlier.
Yes, Your Honor. So I think the biggest example is evidence of net margins that was presented in the form of a single line from a deposition testimony from BHI's corporate representative.
Okay, I mean, because Mr. Richie says it was not untimely because he says the court had granted extension. Focus on that for a minute.
Well, that was not subject to the court's extension. So that was from a deposition that was taken after the formal close of discovery, but by the agreement of the parties, the deposition did take place after that, but before summary judgment briefing. And so that deposition testimony was available when BHI filed its response brief. But in its response brief to the summary judgment motion and its objections that it presented to the district court of the magistrate judge's report, BHI did not present any deposition testimony other than gross revenues, which is not sufficient under Texas law. The proper measure of damages under Texas law is lost profits. And BHI attempted for the very first time to introduce this single line of deposition testimony from its own corporate representative with a unsupported allegation of net margins of 10 to 11% for the first time on appeal. And so the district court never had an opportunity to consider that evidence, and we never had an opportunity to argue to the district court why that evidence does not create a genuine issue of material fact. And by failing to raise it with the district court, the BHI forfeited its ability to do so on appeal, which again, is separate from this motion to compel. That deposition testimony was not part of the interrogatory response that was later subject to the motion to compel. But by the way, even though the court did compel BHI to respond to this interrogatory after the deadline for summary judgment, BHI had the ability to and the obligation to respond to this interrogatory at any time during the discovery period. And BHI did not serve its response to the interrogatory requesting a detailed description of its calculation of its damages until 11 days after summary judgment briefing had been completed, 3 months after the close of discovery, and a year after defendants served the requesting this information. And so it was always within BHI's power to respond to that interrogatory, and the fact that they didn't do so until compelled by the court does not mean that they should not have done so earlier. Before continuing my outline, I would like to address a few points from the discussion with my colleague. First of all, this 1961 Hambris case that BHI cites in its brief, it's just a 2-page summary opinion that does not have anything to do with the sufficiency of evidence from which a jury can award damages. And I just want to point out, defendants are not seeking to win on a technicality, but we're seeking to show that under the Texas substantive law governing damages and under the federal procedural law on the summary judgment standard, BHI has not presented evidence of damages from which a jury could award damages. And 2 long-serving and highly respected judges have already carefully considered the evidence that BHI presented on summary judgment and agreed that there was no evidence from which a jury could calculate damages.
If I understand what you're saying, you've already said it before, but I want to be sure. That's because, in your view, they only presented gross revenues, and that's insufficient under Texas law. Is that right or not?
Yes, Your Honor, and the only evidence that they submitted in support of lost revenues was raised for the first time on appeal. There are other reasons that I'd be happy to discuss where we believe that evidence is also independently insufficient to create a genuine issue of material fact. But I think that the most important argument is that BHI has a history in this case of attempting to have multiple bites of the apple long after the deadlines have closed. And unfortunately, the district court saw fit to harshly criticize BHI's repeated history of procedural failures. And that is directly relevant to this appeal because even on appeal, BHI is relying on arguments that it has forfeited by failing to timely raise those when it should. Not only arguments, but introduce new evidence. And I'd like to point out something that even just in the oral argument BHI has introduced that was not in its appellate briefing. Mr. Richie cited to deposition testimony from Brian Hoffman and Dustin Coble, and those are nowhere in the brief. The only deposition testimony to which BHI cites and is properly before this court is testimony from Shelby Walker and Ken Loynes. Now, the main testimony and the only testimony that was properly before the district court, again, goes to gross revenues, which is not the proper measure of damages under Texas law. And then on appeal, they also introduced this new argument new estimate, which is again unsupported by any objective facts, data, or figures of the corporate representative's own ipsy-dixit statement of what he contended the gross.
Okay, I was going to ask you about the testimony. Mr. Richie brought up 4 pieces of the record testimony to support what he says is a non-speculative damages model. Walker, Hoffman, Coble, and president of BHI, is that Loins?
Yes.
Okay, that's 4. My first question is any of that evidence the subject of the procedural rulings in the case, the motion to strike, the motion to exclude evidence as hearsay, that sort of stuff? Is any of that subject to the procedural rulings?
I think that to some degree the Hoffman and Coble
Okay.
are subject to the...
Yeah, because you said that they weren't in the brief.
They weren't in the brief. The only time that those come up are arguably referenced in the interrogatory response that BHI untimely filed. And by the way, Judge Lindsey refused to consider that interrogatory response, and his rulings on evidentiary issues are subject to a highly deferential manifest.
Yeah. So my follow-up question is, given this testimony, Walker, Loins, throw in Hoffman and Coble just for the sake of argument. Can you explain to me why that testimony doesn't establish a acceptable damages model?
Yes, Your Honor, because none of that testimony is supported by objective facts, figures, or data, which is required under the Texas Supreme Court Holt-Atherton case, which must be any evidence of lost profits must be based on those objective figures,
Okay.
which they're not.
So you say that doesn't do it. Now, my last question is, let's assume that we include all of the evidence that's been excluded in this case. Their evidence has been subject to a motion to strike, exclusion for hearsay. I read all the magistrate's rulings. Let's assume all that evidence came in. Would you lose then?
No, Your Honor.
Okay, why not?
There are independent reasons why, even if it came in. And so on the deposition testimony, as I've already explained, the estimates must be based on objective facts, figures, and data, which they've not provided, even though they had a duty to disclose under Federal Rule of Civil Procedure 26A, even without a discovery response, a calculation with supporting evidence. They agreed in response to a request for production to provide documents in support of their damages. They never did that. And Ken Loins testified in his deposition that BHI has the information to support its lost revenues, and even said that they had run the calculations, but they never disclosed the calculations or the underlying evidence. Further, there's Texas case law, again from the Texas Supreme Court, the MBM case from 2009, that says that mathematical precision on damages is not required if the plaintiff provides the best evidence of the damage of which a situation admits. And again, as I just explained, BHI has agreed that it has the information, it had a duty to provide it, but it has never provided anything other than an ipsy-dixit statement that was presented for the first time on appeal that our margins are 10 to 11%.
One of the things that the magistrate judge found or mentioned was that BHI never answered interrogatory number 16, which asked for a detailed calculation of damages. Would you address whether that was an accurate statement and what part that plays in your argument, if any?
Yes. Well, first of all, I'd like to just say that anything that's cited in their answer is, again, not based on any objective facts, figures, or data. They cite a...
Just answer my question directly. I'm asking you about interrogatory 16.
Yes, sir.
You can tell me that that's irrelevant to your argument. That's fine. I just want to know, because the magistrate judge specifically said they didn't answer interrogatory 16.
Well, they did not. And so some examples of the categories of damages that they included are loss of future revenue with Encore due to reputational damages. That does not explain any calculation or any range of what they think those damages are. They state in this response to 16, loss of potential business and expansion in the market due to damage to reputation and lack of resources, loss of goodwill within the Texas market, loss of BHI's trade secrets and confidential information, value based on the time and resources expended in their development, but there is nothing in any of those responses that gives any indication of how those damages should be calculated or what any sort of even ballpark estimate of what those damages are.
Okay. Anything else?
Yes, Your Honor. I'd like to briefly just explain the 4 pieces of evidence that BHI did cite in its appellate brief. I think I've already explained the deposition testimony and why we believe that first that was forfeited and should not be considered, and also is entirely unsupported. They also have this interrogatory response, which I think that we've explained. Again, Judge Lindsey did not consider it because it was raised for the first time on the objection, was not raised before the magistrate judge for reasons that were completely within BHI's control. And BHI does not even explain in its brief how the interrogatory response would create a genuine issue of material fact. It basically just cites to that interrogatory response with no explanation and expects the court to sift through the record. And as we pointed out in our brief, many of the deposition excerpts that are cited in purported support of their damages are not even in the summary judgment record. And so even if this court were inclined to go look them up, they would not be found in the record. And on the FTI report, I want to briefly talk about this because this is another document that the BHI says supports its damages, and that report was stricken on the dual grounds of being untimely produced and of hearsay. And again, that's a highly deferential manifest error standard of review. But I want to point out that BHI has only raised that document as purported evidence of the cost that the vendor undertook to perform the analysis. And the report itself, which includes the findings of this vendor, which again are hearsay, does not say anything about the cost. So BHI didn't produce an invoice or a payment record, but it's very important to keep in mind that there's nothing, and BHI has admitted there's nothing within the report itself that gets to any form of damages other than what BHI might have paid this vendor FTI to conduct the report. And so that, aside from being properly excluded, provides no evidence of damages. And then finally, there's this unsworn tooling list that the district court properly excluded as inadmissible hearsay. BHI has never argued that that document is not actually hearsay. It argues instead that the document should be admitted because defendants first presented that document in support of its in its opening summary judgment brief. But it's very important to note why we included that document. We did not include that document because we were intending to rely on it in our defenses anyway. We raised that document to say the only potential document in the production that BHI has in support of its conversion damages is this unsworn list that is just a list of allegations of tools that BHI discovered to be missing and the alleged cost of each. And this is a hearsay document. And so when you see them present this, understand that this is hearsay. And so the fact that we first raised it certainly does not mean that we waived a right to argue that it's hearsay, because that's the very argument that we were making. And finally, with my remaining time, I'd like to briefly address the other reasons unrelated to damages for which the magistrate judge conducted an analysis and recommended dismissal for reasons other than damages, and that was 9 of the 13 causes of action. And BHI did not address those issues, even though it had plenty of space in its opening brief. And Judge Lindsey did say that he did not need to address the arguments other than damages, because that disposed of the entire case. But he didn't say that he did not consider them. In fact, he expressly stated that he considered the summary judgment briefing, the magistrate judge's report, the case record, and that he also conducted a de novo review of all of the portions of the report to which BHI objected. And on those bases, consideration of all of that information, he, without reservation or qualification, accepted the findings and conclusions of the magistrate judge and accepted them as the opinion of the district court and overruled all of BHI's objections. In fact,
So is it your view that that was a ruling on the merits? Because Mr. Richie says it wasn't.
yes, Your Honor, because he said that he considered all of the objections, and BHI did raise in its objections to the magistrate judge's FCR the other reasons unrelated to damages, and Judge Lindsey said that he considered those. And in fact, on footnote 7 on the last page of the order, Judge Lindsey itemized the information that he did not consider in making his ruling. And he did not state anywhere in that footnote 7 or anywhere else in the opinion that he did not consider those other reasons. He only said that he did not need to address them. I see that I've ended my time, so thank you very much.
All right. Thank you, Mr. Cooper. Mr. Long Daniels for rebuttal.
May it please the court. I'm David Long Daniels. I'm honored to be here today to respond to your inquiries and to address some of the issues. Let me start off with saying this is a case where there's no debate that they stole our equipment. There's no debate that they took our information. What they have asked you to do, despite of their theft, is to not reach the merits.
Where do I find a finding? Is there a finding below that there was theft?
They admit it. I took the deposition of their president. We talked about the tools they stole. He admitted his guy stole them. He admitted he never gave them back.
So, okay, so because I read the magistrate's report and I read the district court's report, I just don't remember there being a finding of that.
There was no finding from the magistrate judge or the district court, but it's not disputed.
Okay.
We can't ignore their admissions that they stole something that didn't belong to them and refused to return it back. They would have you rule on procedural issues. I've been practicing law 35 years. It is the core function of the court to get to the merits of the parties' issues and not to let procedural issues be the litmus test of right or wrong. Here, even their procedural issues are sort of a misnomer. For example, we talk about the testimony that established damages. There were 4, but let me remind you that the major one was the CEO and founder of the defendant, who admitted that per crew, you lose $100,000 per month. And I said, well, if it's $100,000 per month, then that's $1.2 million per crew. He said, that's right. Then
Revenue or profit?
that is revenue. Then Shelby Walker, who they say is a lineman, but actually was a person that was a foreman of a crew, said that was his experience as well. Ken Lawrence testified that they were right, but he said, we have a 10% margin. Tell me why that is not enough for the jury to make the decision on damages, especially when I have these defendants on CEO agreeing with the calculation. Why is that not a jury issue? They talk about the tooling. Well, there's no dispute that there was tooling taken. There's no dispute that during the deposition of Ken Lawrence, my president and CEO, before the end of discovery, he laid out his tooling and what it cost. And they say, well, that wasn't disclosed timely. Well, it was before the end of discovery. Then we talk about the motion to compel. And it's kind of a clever issue. They filed a motion for summary judgment, and they filed a motion to compel. The judge's order said that the response to the motion to compel had to be done, and it was done, by January 22nd, 2024. We did it. There's no dispute about it. Now, that just happened to be after the time frame for the motion for summary judgment evidence to have closed. By the court's own order, we were compelled to produce something after the discovery time period for introducing evidence was closed. Now, the judge said, well, there's no evidence that it's been done. Of course not. Under our procedures, we don't tell the court when we have submitted discovery responses, but there's no dispute about it. I ask you, let's get to the merits. Something wrong has been done, and we've come to the court, the only place that relief can be granted, to deal with the merits. I think there's no greater mission of our profession than to address the merits of a party's dispute. And I beg of you, let us not let procedural issues, whether something was done timely, whether something was done in accordance with some procedural issue, determine the merits of what is a clear theft by these defendants. That is our core mission as lawyers, as officers of the court. I would ask you just to consider those issues. And if you consider it, you'll find there's no dispute that a theft occurred. There's no dispute that there were damages. Those damages were produced in accordance with the court's order. Those damages were admitted to by these defendants. What more do we need for the jury to consider than their own admissions? Thank you, Your Honor.
Thank you, Mr. Long-Daniels. Your case and both of today's cases are under submission, and the court is in recess until 9 o'clock tomorrow.